We know it can be kind of frustrating trying to catch your team's game online or on television. Whether you can access it seems to turn on which subscriptions you have, and it sometimes feels like you have to buy every team's games just to get your own. In Laumann versus National Hockey League, we examine a consumer attempt to challenge this broadcasting landscape on the basis of antitrust concerns. The National Hockey League, or NHL, was comprised of professional ice hockey teams. Major League Baseball, or MLB, was comprised of professional baseball teams. Each team within these leagues had the initial right to control its home game telecasts, and the teams all agreed to allow each visiting team to produce its own telecast. Telecasts were usually produced by arrangements between individual teams and regional sports networks, which generally broadcast most of a local team's games within the team's telecast territory. These networks sold the telecasts to subscribers through companies like Comcast and DirecTV, known as multi-channel video programming distributors. However, these telecasts only featured the respective local teams playing within the regional network's territory. Games played by teams outside this territory were blacked out on these networks, which meant that access to out-of-market games could only be obtained through national internet or satellite-based media subscription packages offered by the leagues. These packages, however, were all or nothing, in that they included all the league's thousands of out-of-market games, even if a customer was only interested in one or two teams. In these packages, the leagues also blacked out local games, so that a subscription to the regional cable sports network was still necessary to see those. Thomas Laumann and Fernanda Garber were two subscribers to these all-or-nothing, out-of-market NHL and MLB television or internet packages. Laumann, Garber, and others brought this consolidated class action against the NHL, MLB, regional sports networks, and the multi-channel video programming distributors in district court, alleging that the agreements between these groups violated the Sherman Antitrust Act and that the parties conspired to restrict access to games and quelled competition, thereby increasing consumer costs. The leagues and others filed a 12b6 motion to dismiss.